Good evening. At this time, I would like to call the meeting to order. Today is Thursday, October 24th, 2024, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded seized territory of the Gabrielino Tongva and Gabrielino Kizh peoples. Vice Chair Rory, would you please lead us in the Pledge of Allegiance?
Please stand if you are able and repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. We'll give this just a moment here, and then we will do the roll call in just a moment. I think you can begin.
Commissioner Goldman?
Here.
Commissioner Kerpes?
Here.
Commissioner McCafferty?
Here.
Commissioner Paris?
Here.
Commissioner Topshin?
Here.
Vice Chair Rory?
Here.
And Chair Bass?
Here. We have a quorum. Has everyone had a chance to review tonight's agenda? So is there a motion?
Motion to approve the agenda?
Second.
Motion by Commissioner Kerpes, Vice Chair seconds. May we have a roll call, please?
Yes. Commissioner Goldman?
Aye.
Commissioner Kerpes?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Rory?
Aye.
And Chair Bass?
Aye. The motion carries. Approval of the minutes. Have you all had the opportunity to review the minutes of October 10th, 2024? If there are no changes, I will move to approve.
Second.
May we please have a roll call?
Yes. Commissioner Goldman?
Aye.
Commissioner Kerpes?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris?
Aye.
Commissioner Topshin?
Abstain. I was out at the last meeting.
Noted. Vice Chair Rory?
Aye.
And Chair Bass?
Aye. The motion passes. Now we move on to an area of our agenda for public comment. Do we have any speakers from the public?
No speakers tonight.
Thank you. There's an opportunity at the end of the meeting. If somebody is at home and really wants to speak to us, you're welcome to join us. Next item on our agenda, number 7, is the manager's report. Mr. Kessinger, do we have a report?
Yes, thank you, and good evening, Commissioners. It's nice to see you all. Tonight, October 24th, we have Appeal D4831CD. We also have an agendized item of a discussion of RSC meeting schedule through 2025. You'll notice moving forward that for the next 3 meetings, we have 3 appeals scheduled. This is not customary, but it just reflects a desire from staff to ensure that we're able to hear these appeals in a timely manner, given that the second meeting in November is canceled and some of the lack of quorum issues that we had leading to cancellations earlier. But that won't be the plan perpetually moving forward, just for the next couple of weeks so we can catch up. That being said, on November 14th, we have Appeal D4884, D4877, and D4916. On December 12th, we have scheduled D4889, D4804CD, and D4689CD. On December 26th, we have scheduled D4750CD, D4920, and D4948. And then moving into 2025 for the first meeting of the year on January 9th, we have D4950 and D4949. That concludes the manager's report. Thank you.
Thank you very much. Do any of the commissioners have any questions for the manager? Seeing none, we will move to the appeal portion of our agenda. We have an appeal before the commission this evening, which is appeal number, too many pages to flip through, D4831CD for 7635 Hampton Avenue, number 11. Do we have a representative of both the tenant and the landlord?
Just the tenant is present in chambers tonight.
Great. And first, we will hear a staff report from our legal counsel, and then we will have the appellant, the tenant, speak first. You'll have 5 minutes to provide your argument. Normally, you have the opportunity to divide your time halfway, however you would like, but because there will be no other party speaking, you'll just use your full 5 minutes. At that point, the commission may or may not have questions and will enter into deliberation. Mr. Martz, may we have a staff report?
Good evening, Commission. My name is Kellen Martz, Legal Counsel to the Rent Stabilization Commission. Tonight, as noted, we are having Appeal D-4831CD. Reminder, CD is for compliance determination. In this matter, and I apologize if I butcher the name, Yuri Levochkin, the tenant, has resided at 7635 Hampton Avenue, number 11, since 2005. The current owner is Hampton Avenue LLC. In this matter, the tenant filed an application on December 4th, 2023, which sought a rent decrease for several issues relating to the unit, as well as building common area issues. A decision in the matter was issued on February 14th, 2024. That matter was not appealed. Accordingly, staff will have you defer to the original decision for any background matters on this. However, the original decision did grant both common area and unit-specific rent decreases. The common area rent decreases were regarding an on-site manager, garage lighting, and building lighting on the side of the building. The unit-specific issues that were rewarded with a rent decrease are the carpet, the interior paint, the stove, and the shower doors. The total reduction for the tenant in question tonight is $270. Once that was issued, the landlord filed a request for a compliance determination stating that they had completed the items related to the unit-specific issues. That was stating that they had replaced the flooring, they had installed a new stove, installed new shower doors, and repainted the interior unit. Subsequent to that, the tenant filed a timely objection. They stated that they did not agree with the compliance determination request because the interior unit painting was not completed due to doors being in the same condition, and that only one of two shower doors in the unit were replaced. No comments were provided in the tenant's objection as to the cooktop stove issue or the carpet and flooring. In these matters, the person doing the compliance determination, which is generally the original hearing examiner, can request a hearing or schedule it. In this case, they did not. On June 13th, 2024, the hearing examiner issued their compliance determination, which restored the rent for the unit paint, carpet, and stove. However, the hearing examiner did not restore the rent for the shower doors. The hearing examiner addressed both issues in the tenant's objection. The hearing examiner in the compliance determination found that the landlord had complied with the original decision, and they based that off the interior photos, the landlord's statement, and the painting invoice. They found that there was sufficient evidence in the record to show that the work had been completed, at least to substantial compliance. However, as to the shower door issue, the hearing examiner found that the original decision required repair or replacement of the shower doors in the plural. All that was submitted in the compliance determination was evidence of a singular shower door being repaired or replaced. Therefore, the hearing examiner found that there was not substantial compliance with the original decision as to the shower doors because only half of the shower doors were replaced. Therefore, the rent was not returned to the original amount on that decision. And in this matter, staff has reviewed everything and finds that the hearing examiner did not err in his review of the compliance determination and the tenant's objections. There was substantial evidence in the record as to the interior painting, and staff also agrees with the analysis on the shower door issue. There wasn't a lot provided by the tenant in this case, but the landlord bears the burden when they ask for the rent to be restored, and in this case, that burden was not met. You have the power to affirm, overturn, or remand the decision, and that concludes my report.
Thank you very much. Are there any questions of the commission, of staff? Commissioner Thompson.
Thank you, Chair. I think I have one or two questions, sort of a procedural questions. I don't know whether the legal counsel or the Mr. Manager will respond. So the objections to compliance determination was filed on May 14th by the tenant, and I think there is an email that the city staff sent to internally, forwarding the email from the tenant where the tenant specifically mentions that, number one, repaint unit not complete, doors is apart.
Commissioner, are you referring to page 56 of the packet?
Let me see. Yeah, I think it's, yes, Commissioners, it's page 56 of the packet. So the mentioning the doors as as part of the unit is still at same condition. So I think that my question would be, the objection was filed on May 14th, the compliance determination issued on June 13th, almost in a month. What happened between these two dates, almost within that 1 month period? Is there any procedure that, let's say, someone from the department will contact the parties, or in this case, the tenant, and explain the procedure, what type of evidence the tenant should provide in order to support the objection? I think that's one question that I have.
So in that situation, it's generally up to the hearing examiner about what that process is. It is up to the tenant to submit what they think is appropriate, so staff doesn't really guide them in that. The hearing examiner can set it for a hearing, like I mentioned before. They can send out generally code enforcement or a staff member to look at things, or they can just review the record, and if they feel they have enough evidence in the record, then they can make the determination without any of those steps.
Okay. So, and we don't know if there's record of the tenant within these dates going to the department and asking for, additional information or guidance, or you probably don't have any record of it.
From what we have in the record, the email was what was submitted
That's
for
the
this
only
matter.
thing. Okay, thank you. And the other question, I think I missed that part. You mentioned that, clearly the hearing was not held on the request, but is this typically when the examiner determines the hearing is necessary, or it's the parties they may request the hearing?
The hearing examiner would make that determination.
Okay, and in this case, the examiner was satisfied by the evidence, which is regarding the paint, there's 5 photographs, and the painting invoice.
Correct.
All right, thank you, sir.
You're welcome.
Any additional questions at this time?
I have a question. So if, looking at this, this invoice and the photos, if we think that this might not be sufficient, is there any, can we ask any further questions, or how does that work?
Yes, you can ask questions of the landlord and the tenant. The landlord is not here this evening. However, this is a reasonable person standard, so you don't, even if you feel that the hearing examiner went a different way than you would have, if there's substantial evidence in the record that supports what the hearing examiner decided, that's what you have to go with. Even though if it's, could have gone either way, if you find that there's substantial evidence in the record that supports what the hearing examiner decided, then that is what the rules and regulations require. But you're free to ask probing questions of parties to determine if that makes sense to you.
Can I ask another question?
Sure.
I guess, because I'm looking at this invoice, does the city, or are there any rules about an invoice being from an official company? Because this it looks like a Word document that somebody put together, and so I'm wondering, have we know?
Yeah, there are no, that goes to, the validity, not that it's actually done or not. So you're free to feel that it's good, bad, or otherwise, but there's no rules required by the city. It has to be on a certain form or anything.
Okay.
Thank you, Commissioner McCafferty.
Apologies if this is tedious, but I feel like it's worth bringing up on page 13 of our packets. The questions to be determined. I just want to confirm that that's a typo. Under A, it says regarding the roof access and amenities.
Yes, that is. Let's see here. Yes, it would be regarding the interior paint and the shower doors.
Okay, great, thank you.
Thank you. Any other questions? Commissioner Paris.
Sorry. Yeah, the report says that the compliance determination differs from the traditional rent decrease application procedure. How does it differ?
So, in the traditional sense, which I think you've heard before, they come in and say they didn't fix or they haven't painted in X number of years. There's nothing that the hearing examiner has at that point, so they do have to file a hearing. What the process is here is there's already been that hearing, there's already been a determination made. So it's not like they're kind of going in the dark. They go off of that original decision, and that's the guiding principles that they are kind of constrained in reviewing things. So it's almost like a second bite at the apple type of thing, where there's already been a hearing, there's already been the parties before that. So that's the main difference.
Thank you. At this point, we'll invite the tenant to come up and speak. You will be given 5 minutes. At the beginning of your time, please state your name, your city of residence, and you're welcome to begin.
Hi, my name is Yuri, last name Levochkin. I'm tenant 7635 Hampton Avenue.
Please
apartment
speak into
11.
the mic.
Huh?
Please speak into the mic.
Oh, sorry. My name Yuri, last name Levochkin. I'm living 7635 Hampton Avenue, apartment 11, since like 2005 August, almost 20 years. And regarding my appeal, what can I say? They did a painting on my unit, but not completely done. It means like doors missing, I mean the paint of the doors missing, frame of the doors. And regarding the bathroom, I mean the shower doors, we have 2 showers. I mean 2 bathrooms and 2 shower doors. They fixed one, but second one just on the same condition. I live in there 20 years, and I saw these doors, you know, like 20 years. And they was there before. And now they molded and rusted, and I just want to, you know, I'm not looking for, like, make my rent lower. I just want to fix this problem, and that's it, and be friends with my management or everybody around. This is it. Thank you.
Thank you. Before you sit down, let me ask if any of the commissioners have questions. I see Commissioner Kirpies, you're saying yes?
Yes, please. So as I understand it, even though you may have appealed I don't think you meant to appeal the doors. The doors were denied, right? The compliance was denied. So you continue receiving the discount on the doors. And I know you still want them fixed, but in regards to the paint, can you tell us more about what wasn't completed on the paint?
All right, the painting not done by the professional guys, like some handyman, wherever with the 2 left hands or something. We have shadows, missing like parts of the walls, not painted. And we have doors. I have like 6 doors inside my unit, like bedroom doors, closet doors. They skip them. And when they do the repair, I asked them, guys, you already here? Do it. They said, no, it's not on the list.
I'm sorry to interrupt. Did those doors that you're talking about, are they doors that were painted before too? Or, because I mean, my house, they're just all brown wooden doors.
It wasn't been painted since 2005, I think.
But they had been painted like previously?
Yeah, yeah.
Okay.
Now not.
So they would
They
be...
scratch it, you know, like, it looks ugly.
Okay.
This is it.
Thank you.
Thank you.
What color are the doors currently?
Like white, dark white, something, yeah, white.
And what color are the walls around it?
White.
But so just the framing and the doors are
Yeah, the doors now is yellow. They're not white. They
a faded,
it
ugly
looks
yellow.
ugly, old color, you know. Yeah. This is sorry for taking your time, guys.
That's
It's a
okay.
simple thing.
We appreciate you coming down. Is it just you that lives in the apartment, or are there children or other family members?
Me and my wife.
Okay. And how, what's the texture of the doors? Is there splinters and paint flecks and other, can you put your hand on the door frames, or is it not safe to touch?
They safety, but looks ugly, actually, you know. It should be painted. Because
So
they
it's
have
just aesthetic?
Yeah, yeah.
And how many door frames?
1, 2, 3, 4, and 3 closet doors. I have wood closet doors, you know, like book style, you know, like open like this.
Okay. Thank you.
Plus front door, sorry.
Commissioner
Plus
Thompson.
front door?
I mean the main door, yeah, front door, yeah.
Commissioner Thompson.
Thank you, Chair. Good evening, Mr. Levochkin. Question which I asked staff at the beginning. Were you, I know on May 14th you sent this email explaining that the paint was not complete, and you specifically mentioned the doors that are in the same condition that were not repainted.
Yeah.
Were you aware at the time that you had to provide any sort of a evidence meaning like photographs that would show these doors are the same condition, that were not painted? Were you aware of that?
I showed it on the last hearing in West Hollywood City.
No, but what I mean is on May 14th when you sent your email saying that, hey, my doors were not
When I sent
repainted.
email, I was out of country. I cannot do pictures in the same time. When I went to my home, I did the pictures and provided them.
Were you told at one point that you need to provide any evidence that would support your claim that?
I provide like couple of them, you know, like I don't want to do the 8 pictures of the 8 doors. No reason, you know, it's just simple, you know.
All right. I think at this point I'm fine. Thank you.
Any more questions? Thank you very much. That will be it.
Thank you.
For public comment. We'll close the public hearing at this point in time and open up the, are there questions for staff or anything at this point, or should we start deliberation? Commissioner Thompson.
Thank you, Chair, again. I guess I volunteered for everything today to be the first person.
Go for it.
Oh, you did the pledge, right. So the reason why I'm asking all these questions...
Just 1 second. You're welcome to sit down. Thank you.
Can I go?
Yes, you're welcome to sit down, and we'll make our decision right now. You'll be able to hear our decision.
All right. Thank you.
If you want to stay, you're going to hear what we're going to decide right now. Okay. Have a good evening.
So the reason why I'm asking all these questions is because procedurally, I think the parties need to be aware that what type of evidence the examiner is expecting to receive. So, ordinary person wouldn't file a complaint, wouldn't know what else that he or she needs to provide. So in his, in the tenant's mind, I think, sending the email saying, hey, my doors were not painted, that's sufficient to say that, the job was not complete. So that part that makes me kind of really not happy with the outcome or with the affirming the decision. And also another thing is that, of course, I'm not substituting my, my judgment for what the examiner decided. But so what I don't really agree here with the examiner's finding is that the examiner made a decision based on solely on that. As the commissioner noted, that Word document that shows the paint unit interior $825. We don't even know from, or we have a name, I guess, on the top and the invoice number. But so let's say that's the invoice. The examiner didn't have any objection because the tenant also obviously agreed that the paint. The unit was repainted, but the other documents the examiner used is this 5 photographs, which I would exclude one of them, which is on page 52 of our packet, because it's a photograph of the stove and the tile wall. So a tile wall that doesn't really show any paint on this picture. So all other four photographs would show some of the parts of the walls or ceiling that would show presumably they were painted. So I don't know if this was sufficient. If again, I don't believe this is sufficient to determine that the entire unit was repainted as the original order states. It has to be the entire unit, and that entire unit, it also includes the doors. So, and that's the part that makes me uncomfortable to affirm the findings of the examiner at this time. So I have no, obviously, objection about the shower doors because the reduction continues. But as for the paint, I want to hear from the fellow commissioners. Thank you, Chair.
Thank you very much. Commissioner Paris?
If it's okay, can I ask staff questions? Or
Of course.
Can we do that? Do we know when, I'm sorry, I'm looking at the broader agenda packet and I don't have the page numbers right, but it's page 63 of the broader packet. There are two images attached as, I guess, part of the evidence. One is looks like a screenshot, or they both are screenshots of the property in the main common area, the main living area. It's image 8237. Do we know when that image was dated or submitted as evidence? Was it before or after the determination?
These were submitted by the landlord as proof that the work was completed.
Okay, thanks.
And I would note that the one that you reference, 8237, I believe was submitted not as proof of painting, but of the floors. But it does show some of the paint, so that's why it was included in your packet.
I see. I can tell from that image that the doors appear to not be freshly painted, as is part of the claim. I know that that's specific to the flooring, but if the claim is that the landlord painted the whole unit, then it's old and faded and yellow in tint.
Which
Thank you.
doors? Sorry, which doors are you referring to? Oh, in the, what page?
Commissioner McCafferty?
Yeah, noting kind of in the scope of in our packets on page 12 at the bottom, it's saying in the staff report, it would have been helpful if the tenant provided more proof, like a close-up of the doors. However, the burden of proof lies on the landlord, so my analysis is in that scope. If you showed me the pictures provided and the invoice, I don't think a reasonable person could agree and say that yes, the whole unit has been freshly painted. So I disagree with that part of it. I think that they should be repainted and you need more proof. And then as far as the shower door, I agree that there isn't enough proof to show that both bathrooms' shower doors have been replaced.
Thank you. Commissioner, we'll go down the line. Commissioner Kerpes.
So the problem that I have with this case tonight is I think that the hearing examiner did exactly what I did when I was reading the case, and that was kind of possibly with the handwriting and the accent, kind of dismissed the arguments about or not dismissed, but just kind of looked past the arguments about the doors, making the assumption that the doors that he was referring to, he kept referring to the doors of the shower, when really he has been making two separate arguments: shower doors and housing doors. And I didn't automatically think of that because my doors at my home are not the type of things that you'd paint. They're wooden, you could paint them, but they're not. I wouldn't expect them to be repainted. But that's not the case in this situation. And it bothers me that the hearing examiner, and it looks like the hearing examiner, the reason I make the assumption the hearing examiner did something similar is because when I look at the initial decision, while this would have been an easy one to determine as a hearing examiner in this case because it was clearly past the 4 years, there was no record in our information about the tenant's argument. He basically summarizes it in a very simple way that it's older than 11 years or older than 4 years, it automatically has to be done. So that's the entire paragraph about repainting the unit. And so when the landlord, or when the landlord then tried to be in compliance, found in compliance, he submitted, what he submitted, and it looks like, that might have been the case, but the tenant specifically objected on a very specific issue, and that was the doors. And none of the, you must have better eyesight than I have, Commissioner, because I can't tell either way whether that door is painted or not. So if I were the hearing examiner in this case, I would have either asked for a hearing or asked to see the doors, since they specifically said the doors. When I first read this, I just thought he was mixing up the doors with the, kind of combining the two together, but I see now and I understand now that he's not. So I think that the hearing examiner did err and did not fully evaluate it correctly.
Commissioner Kerpes, I just want to, I don't know if everyone has seen, but, and you might have said this differently, but I want to direct everyone's attention to the actual compliance determination in your packet. For me, it's page 51. I have a slightly different setup than you on the staff side. But if everyone goes to the compliance determination, it's towards the end of your packet. It states on the issue of painting, the landlord was ordered to repaint the unit. The landlord presented evidence that it was repainted, including a photo and the cost. And then the tenant acknowledged the unit had been painted, but he claimed the doors of the unit had not been painted. So I don't think the landlord messed up and mixed the shower doors with the doors. Where what staff read it as is that the standard is they don't have to 100% comply with the original decision. They just have to have substantial compliance. It's up to the commission to determine if that was an error or not. But that is where I think the hearing examiner made his determination, was that the unit itself was painted, the doors were not, but it was still substantial compliance. And because the tenant had not provided evidence that the doors were or not painted, they lean towards the landlord's decision.
And which page are you looking at? Sorry.
This is the compliance determination on the first page.
Not work performed by the landlord? So the compliance determination?
Yeah, it's signed by hearing examiner Jamar Boyd Weatherby on the second page. But on the first page.
59. Page
Yeah,
59.
sorry, this one was the one I was looking at.
And on page 1, about 2/3 down the page, on the issue of painting is where the hearing examiner speaks to that issue.
And then what you just said before, saying that the tenant didn't give proof, I'm just confused because in the staff report, it says that the proof is on the burden of the landlord.
So the burden is on the landlord to prove that they did the work when they submit the compliance determination request. However, for the appeal that we have tonight, the burden is on the party filing the appeal. So to have this overturned in his favor, the burden is on him to prove that.
Excuse me on that one, but they're not allowed to present new evidence to us tonight. We can only look at what the hearing examiner had. So how would they be able to meet that burden if they can't give us new information that the hearing examiner didn't have?
So
I'm just trying to wrap my head around that.
Yeah. So they have the burden of proof in their explanation of why you should overturn it. However, you can only look at evidence that's in the record. So originally, when they submitted their objection, that was the time for them to submit X, Y, and Z.
Thank you. Commissioner Kirby, you want to continue?
Oh, I'm done, but I just have a question about that. About the response, when they get the notice of determination or notice that the landlord has requested the compliance, what does the tenant receive? Do they receive the evidence as well?
So it is in your packet. Let's see. Okay, so immediately before the compliance determination that you were just reviewing, there is a document stated work performed by the landlord.
It's page 57 for us.
Yeah.
There you go. And so I don't believe they get the actual evidence. They get a list of items that have been stated to be fixed by the landlord, and then it has the steps there. So I think it was Commissioner Topshin, you were asking about this a little bit, about what kind of notice is given to them or what kind of statements they're told. So if they agree, you don't need to respond to the notice. But if you dispute it, you can file a written statement. It does set forth additional documentation that should be submitted, how to submit it, and then towards the bottom of that page, it goes through the options that the hearing examiner has, whether it may be a compliance determination investigation where someone visits, setting a hearing, or just making a decision based off of the record they have.
I'm so sorry if you're going to give me the same answer again.
That's okay.
I'm just genuinely confused.
That's okay.
So I'm assuming this staff report was written after this appeal that comes before us. And I'm just confused why in part F of this staff report, it says the landlord has the burden of proving
Let me scroll up
they
there.
completed the work.
Correct. So there's multi-steps in this process. So I'll break it down kind of in chunks. So the first thing that happened in this case was the original rent decrease application, right? He gave that long list that said, all these different things are wrong with my unit. I would like the city hearing examiner to look at those. In that case, because he's the party filing the case and asking for his rent to be reduced, the burden is on him to make his case. So that's part one. The hearing examiner made his ruling on those issues, and then once the landlord has done the repairs, in this case, the floors, the paint, and the shower doors, the landlord files with the city and says, I would like the rent reduced on those issues. In that case, the landlord is the one filing and asking for the rent to be restored. So now the burden is on them to prove their case about what was fixed and why they should have the rent returned back to its original number. So that's kind of part two of this process. And now there was the objection. That's kind of the same as part two. And then the hearing examiner made his ruling on that compliance determination request. As you noted, it was granted in part and denied in part. When they file an appeal with this body, whoever files the appeal has the burden. And so tonight, the tenant has the burden of proving that it was in error or contradictory to the rent stabilization ordinance. And so those are kind of the three parts. And so now that burden has shifted back to the tenant because he's the one that disagrees with the most recent ruling and wants this body to overturn it as to the paint.
Thank you. I want to
Thank
get
you.
Commissioner Coleman. You were next, so I wanted to make sure everyone got a chance to weigh in as well.
Yeah, so I think based on seeing these photos, I don't think that you could reasonably tell that it was freshly painted. They're very dark photos, and that invoice is also very unofficial. So are we saying that it's on the tenant? The tenant should have submitted new photos, or is there any situation where somebody can go on site and verify?
So I want to be careful of not trying to influence your decision, but several people have said they don't believe that there was enough evidence from the landlord to make that determination as the paint. What I am hearing, and depending on how you vote, I may have to amend the resolution, but it sounds like what you're saying is that the decision was an error to grant the rent to be restored as to the paint, and then it wasn't reasonable in the situation for the hearing examiner, based on the evidence that they were given, to make that decision. So that's, I'm just trying to kind of parse out a lot of the thoughts there, because those are all legal things that will have to be going into the resolution. And so when the record is clear, it's a lot easier for staff, and if this ever gets appealed up. To your second question, yes, it's up to the hearing examiner to determine if they want a site visit. This might have been a good case for that, but that's the hearing examiner's discretion to do that. But yes, they can ask staff. I don't know, is it code enforcement that would go out?
It's our information coordinators.
Okay, so the rent stabilization department has staff that would go out and do an investigation, and I'm sure there's a process that they follow, and they can take photos and do all that on behalf of the hearing examiner to supplement the record.
That was a good summary, what you just gave of my thoughts there.
Thanks.
Thank you. Vice Chair.
So I would 100% vote to affirm as to the shower doors. I don't think there's any dispute about that tonight. I hope if the landlord is listening that the second shower doors be corrected immediately, and if not, there's a rent reduction in place until that gets done. As to the paint, around the trim and the doors, I don't believe that there has been substantial or really any evidence in the packet that I've seen tonight to support a finding that the trim around the doors has been painted. I would note my view on the image that my fellow commissioner referenced earlier, 8237. I believe that might actually be the side of a kitchen cabinet. So I don't even count that as a door. I don't think there are any examples of doorways in any of the pictures that I've seen tonight, or the trim around the door. And so, because I can't see any doorways or trims around doorways in any pictures, I don't know how a hearing examiner or compliance determination manager could find that those got painted as well. If we had a situation where they were painted, but there were paintbrush hairs in the paint job, or they missed a few spots and it was not done, completely, then maybe I would say, well, that's substantial performance. You tried to paint the doorways. They did a pretty good job, and not a good job all the way. But we don't have that. We don't have any evidence of that. And so I feel pretty comfortable on a remand motion as to the painting, to look at the doors and the doorway, and whether there was evidence submitted that got done. I don't think I really want to wade into tonight making a determination with this body about what that amount might be, but I would feel comfortable remanding that to the hearing examiner. And I would finally note for the record, we heard, and it's in the record, this gentleman's been living in this apartment for a good 20 years. He came down tonight to let us know what his issues were. The landlord previously has addressed several of those issues, which is very encouraging. I hope that that spirit of encouragement continues. But I think as this one issue, it was important enough for him to come down tonight and to tell us what he thought about it. And I really don't see sufficient evidence in the record that the doors and the door frames got done, even substantially done. So I would feel comfortable entertaining a remand on that issue, but affirming on the shower doors.
Thank you. Let me weigh in as well. If others have questions, we can certainly come to them. But I think that the reasonable standard is what makes me question whether or not to affirm, because there is evidence that a painter was hired. There's testimony that a painter came in, but in the work performed by the landlord, the city's statement, and there's a lot there, and it says, that the evidence you submit will help them determine how this is decided and all of that. But it says if you dispute the statement, you must file a written statement by mail or email objecting to the request for the restoration of the MAR no later than May 14th. it says, it goes on to say, your objection may be accompanied by relevant documents. So the may versus must leads me to believe that the tenant, I don't think that they were reading this in any sort of legal way. I think, but that they saw they needed to provide a statement. They said they objected, and there are no pictures of doorways. Vice Chair, there is a doorway clear in the corner here, really in the back. If you zoom in, there is one doorway there. It is impossible with my eyes, even with my glasses on, to see whether it's painted or not. So I don't see any evidence in the record that shows that the doorways were painted. I see no evidence that they were not, but that doesn't create a reasonable person would not say no evidence means it was done, just because one person said it was and one said it wasn't. So I'm interested in either remanding or reversing on that one specific, on the paint. I think we're all in agreement on the shower doors. So that's where I'm at. Only because, there is just no evidence, and I don't think the tenant thought he needed to provide evidence, because the original evidence showed that the doors hadn't been painted, and I mean, if it hasn't been done, it hasn't been done. You send the exact same pictures back, or what do you do? So I think it's difficult. And I agree with the Vice Chair in that if it was just one small little area, I recently asked my landlord to paint the interior common areas, and they did that, but the painter missed one small little section of wall, and I've told them, and they've not come back. I'm not filing a hearing over that because the painter just missed someplace, right? And I don't think that's what's going on here. They missed all of the doors based on the testimony. So I think that's significant and needs to be remedied. Do we have a motion or more deliberation?
I can make a motion, Chair. I'll make a motion to adopt resolution RSC 24-658, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part and remanding in part the hearing examiner's decision as to application D-4831CD1. So affirming in part regarding the shower doors and remanding in part regarding the paint, specifically the doors.
Is the city attorney prepared to have us adopt that resolution? Do you need time to write something?
If you make a motion, or if you vote based on that, I can edit it if we have a 5-minute recess, and I'll read it into the record, and everyone can determine if that's what you were agreeing to.
Okay. Okay. Is there a second for that motion?
I would second it, but with a friendly amendment that we specify the interior doors as opposed, so there isn't any confusion about what doors we're talking about, that it is the unit interior doors and not the shower doors that need to be painted, et cetera.
And door frames.
Well, we say interior doors. I remember you said that the main door is also an issue. So would that be considered the interior door also? Yeah, the main entry door.
Procedurally, we have a motion and a second. Should we vote and then have the resolution read after? I think we should probably hear the resolution first.
Either way is fine. So if you want to do a 5-minute recess.
I'm going to call a 5-minute recess, but I would remind commissioners we cannot discuss any of this case while in recess, just so that our entire deliberation is on record. And we will come back and call for a vote after the city attorney has read the resolution and reminded me of something else apparently.
One quick clarification is the motion that you're making, and the second is that it was clearly in error. Is that what you were stating? The hearing examiner's decision was clearly in error?
If we're remanding, if we're remanding on the paint issue, then on the paint issue, we're saying that the examiner erred.
Yes, got it. That's all I need. Thank you.
Thank you. We're in recess for 5 minutes. Thank you. I'll call the meeting back to order and ask for a report from our city attorney.
Great. Thank you very much, Chair. If everyone has the draft resolution in front of them or can share with their neighbor, I sound like an elementary school teacher, we will start with the heading. And I'm only going to read to you what has been changed, but if you have questions afterward, please let me know. The title now reads, A Resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part and remanding in part the hearing examiner's compliance determination as to application number D-4831CD1. And then if you turn to page 3, the section titled Section 4 has been changed to read, the commission finds that there is not substantial evidence in the record as to the interior unit paint issue, but there is substantial evidence in the record to support the hearing examiner's compliance determination as to the shower door issue, period. The commission therefore remands the matter on the interior unit paint issue and affirms a compliance determination on the shower door issue. The following specific findings are made as to this compliance determination. A, regarding tenants' generalized statements that the work was not performed, the commission finds that the record lacks substantial evidence to reasonably support the compliance determination as to the interior unit paint issue, but does find that there is substantial evidence to reasonably support the compliance determination as to the shower door issue. B, the hearing examiner determined that landlord had met its burden establishing compliance with the order of the original decision as to the interior paint. The commission disagrees and remands on that issue for further proceedings with the hearing examiner. Specifically, the commission directs the hearing examiner to conduct a hearing, accept evidence, and to focus on the issues related to painting of the interior unit doors and door frames. C, D, and E remain the same. The final change is F. The commission finds that the hearing examiner clearly evaluated and weighed the evidence submitted by the landlord and tenant and determined that there was not substantial evidence in the record as to the interior unit paint, necessitating a remand hearing. The commission further finds that there was substantial evidence submitted by the landlord, or there was also not substantial evidence submitted by the landlord as to the shower door issue. And those are the changes that were made.
I'm going to turn to Commissioner Topshin and Commissioner Paris as the maker and seconder of the motion. Does this meet your motion's intent?
Yeah, I think it does, and appreciate it.
I'm happy with that. Thank you.
Do any of the other commissioners have questions? Commissioner Kerpes?
Yeah, does the section where you, where we talk about the remand and the direction to the hearing examiner, does it, I'm afraid, I'm concerned that it might be too limiting in what, because I don't think we, I don't know if we have fully deliberated on the thoroughness of all the other walls. It's just we did notice the discrepancy or the problem with the fact that they didn't focus on the doors. So I don't want to overly limit the hearing examiner.
I can suggest a modification and then see if the people that made the motions agree.
Before you go through that, I had one other piece that I think actually goes to this, and that is you included language that would direct him or her, the hearing examiner, to have a hearing. I think it would be just as satisfactory to send somebody out to inspect if they chose not to have a hearing. So I think it's a matter of collecting additional evidence, and they can determine as a hearing examiner how to do that best. But they need more evidence is where I stand on that. But not to the point I'd vote against it, but I'd like to offer that feedback.
And as to both those issues, it's up to the motion maker whether to incorporate those in, and then the seconder to second again those changes. So I'll leave that up to you to discuss.
I believe the way that the motion, I mean the amended resolution was read is just satisfying to cover the issues that of my concern. But again, I'm fine with the way it sounded.
You won't take a friendly amendment to change it to make it less restrictive?
Well, because the issue, I think, again, if the commission rules that way, obviously, if the commission agrees with you with the not to make it that strict specifically to the doors, so I'm fine with it either. But the way we discussed and what we discussed, and specifically based on the discussion, I think the council made the correct amendment to the resolution. But if you believe, the commissioners, that we have to, make another amendment based on what you're saying, so I'm fine with it either. So.
I think we're all essentially the same place from what I'm hearing in comments. So what if we would a straw poll be appropriate here, just so we get this in the right direction?
Or I can just formally make a formal amendment to the motion.
Or are you amending
I
the
just thought it was a
Make it less
I will
restrict-
formally amend it to make it less restrictive in the areas where both Chair Bass and I talked about, that leave it up to the hearing examiner in terms of the scope of.
That they need to get evidence, but
Yeah.
they can
More
determine.
evidence is necessary for him to make a final determination.
Because I think the tenants, specifically the tenants' testimony was, and the objection was about the doors. So he was speaking about the doors only. So I think there is no question, there's no dispute that the paint was done. So I don't know why we need to look into the things. That's the only reason I thought we just want to address specifically the doors, because the tenant's testimony was about the doors only. So.
And my thought on that was that rather than have the tenant and landlord resubmit pictures, perhaps the hearing examiner would just decide if an independent third party could make that determination, a rent stabilization. So I just don't want to restrict how they have to get that evidence, but rather just telling them that they need that evidence. So I would second the amendment to the motion. And I believe that the way that works, my rules of procedure are a little rusty, but I believe we would vote on the amendment to see if the amendment is adopted, and then we would decide by a separate vote whether or not the underlying motion is approved. So would it be appropriate to make the vote on the amendment at this point in time?
Yes.
Okay.
And I don't know if you want me to read a version of that, or if you want to just vote on basic.
I think we should hear a version just so that we're very clear for the record.
Okay, so the friendly amendment, from my recollection here, only changes section B under, subsection B under section 4. And it would read, the hearing examiner determined that landlord has met its burden establishing compliance with the order of the original decision as to the interior unit paint. The commission disagrees and remands on that issue for further proceedings with the hearing examiner. Specifically, the commission directs the hearing examiner to conduct a hearing or order a unit inspection, accept evidence, and to focus on the issue of interior unit paint, including the unit doors and door frames.
Hearing that, I would ask the secretary to call roll on just the amendment at this point.
And for clarification for the record, this is the friendly amendment that we're voting on.
Well, it's not
The
really
one
friendly
made by-
anymore. It's not friendly. It's just an amendment now.
We're all friends, so I think it's still friendly.
So it was motion by Kerpes, seconded by Chair Bass.
Yes.
Okay. Commissioner Goldman,
Aye.
Commissioner Kerpes, Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Rory,
Aye.
and Chair Bass.
It was apparently a very friendly amendment because I'm an aye as well. So the amendment carries, and I think we can now go to the underlying resolution, which has been read into the record, the changes, and that is to approve the amended resolution RSC number 24658 in regard to application number D4831 CD1. May we have a roll call, please?
Yes. Commissioner Goldman,
Aye.
Commissioner Kerpes,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Rory,
Aye.
and Chair Bass.
Aye. The motion passes. So I'm going to read this statement even though no one's left in the room, but if they're watching online or anyone's watching online, if the parties have any Further questions, you may reach out to the Rent Stabilization Division at 323-848-6450, by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. And next on our agenda, we will move on to new business. This is the Rent Stabilization Commission regular meeting schedule for the remainder of 2024 through 2025. And this is something I asked staff to put on the agenda, so I will begin by saying thank you. I appreciate that we're going to have this conversation, and I'll turn it over to our manager.
Yes, thank you. So I think the intent behind this was just to ensure that there could be discussion among commissioners about the dates that are proposed for 2025 and the dates that have been set for 2024, and sort of be proactive in these conversations to avoid any issues with quorum moving forward. With that being said, I would defer to all the commissioners to sort of look at the dates and discuss any sort of questions or comments that they have about the dates as proposed.
So yeah, and I will just take the lead here, though I usually try to speak last, and that is when the staff was surveying us about our availability on the 26th of December, it raised a red flag to me because that is a date that I could attend if we have to, but would much prefer that we not have a meeting, and I don't know that it is great to have staff to have to come in on the 26th and people in the public. So, but we also heard at the beginning of the meeting that we have an incredibly packed agenda, and by not having a meeting on the 26th, we are going to be pushing 3 appeals into the new year. So let's decide if we want to do that, or if there are any other dates. I am aware that there are holidays that I might not know about that I hope everybody has a chance to look at these and voice concerns about any of the other dates.
Oh, if I can jump in, I'm good on November 14th and December 12th, but December 26th will be hard for me. So even if this body moves forward, I probably wouldn't be able to attend.
Other thoughts?
What were those 3 dates? Were there 3 dates?
They were the 2024 dates.
All 3 dates?
I can do the first 2, November 14th and December 12th, but December 26th would be more challenging.
Okay, sorry.
Just personally.
May I go?
Please.
So if I could start out by saying that I know things are different now that we're 7 members. And also I've noticed tonight that our bylaws have changed since the time that I was going to speak on. But there was a time when we were only 5 members. There was also a time when our bylaws before 2023 specifically limited our cancellations to lack of quorum. We didn't have the option because there was for lack of agenda items. That's since changed. There was a series of probably over a 2-month period where we missed like 6, or probably over a 3-month period where we missed like 3 or 4 meetings. I don't know, Commissioner Chopchin, if you were on there on the commission at the time, but the commission became very frustrated because it wasn't because we were canceling meetings, it was because staff had decided to cancel meetings, and it was back to back, so there was no opportunity for commission to even speak on that issue. And at that time, the city attorney determined that yes, we do need to follow the rules, that only if there's a lack of quorum. Since that's no longer the rule, so, and which I discovered this evening, but one of the things we did do, and I know it would be difficult with 7 members, but what we did back then was we would often at the beginning of the year tell the, or maybe not, it wasn't a formal time, but throughout the year we would tell the secretary well in advance of when we were going to be absent, and other commissioners would participate and do the same thing. And I wouldn't say there was a collaboration because we did it here at the meetings, but there were times when people might be designing or determining a vacation and they still hadn't set the dates yet, but when they find out that one commissioner is going to be gone on, let's say, July 24th, and they're at home trying to figure out what their vacation is going to be, the July 10th or the July 24th, they're trying not to miss too many meetings, they would then utilize that information in their own planning so that we could cancel a meeting rather than show up with only 4 members, or here it would be 5 members. I think we make better decisions when there's 7 of us. I know that we can't always have 7 of us here. I know that the last 6 months were kind of unusual with all the amount of vacancies. I would like to see it where if we've got more than 2 people absent, that we try to not schedule a whole lot on that night, preferably not do a meeting at all. And I think one of the things that would help with that, I don't quite understand the reasoning. I know that the manager's report is to kind of give us an outline of what's coming ahead. To me, I don't find the, and I know this sounds like I'm getting off topic, but I'm really bringing it back in. I don't really find the appeal case numbers relevant or helpful to me. It does help me to know how many appeals are going to be coming up, or I do find interesting that. And I would try to, and I know I'm worried that doing this the way it is, you're actually, the city is actually kind of committing itself to and setting expectations to the landlord and tenant. I don't mind having 3 hearings. I mean, I clear my schedule for the night that we're here. Like, you have me from 7 o'clock on until whenever we finish. So I don't mind having 3 appeals. I know it gets tiring, but I don't mind that. So I would be careful about putting them too far in advance and utilize the days that we are here, that we know we're here, and feel free to load us up on, that's just my opinion, on appeals, as long as we can get our agenda on that Thursday or Friday. And then I just want to say for the record, my days I'm going to be gone, I know for sure, are going to be December 12th. I'm going to be missing, unfortunately. February 13th and May 22nd, I know. There is a small chance that I can come on February 13th, but it's looking unlikely. Thank you.
Do you have any opinion on December 26th?
I can be here.
Okay.
Or not, whatever we determine.
Any other feelings on this calendar? Commissioner Paris.
I just wanted to point out that December 26th is the start of Hanukkah and Kwanzaa this year. I just had the calendar in front of me and I was like, oh, look, I am available. I am not a practicing Jew or person who celebrates Kwanzaa necessarily. So there's no issue for me. I mean, it is the day after Christmas. So to that effect, I would prefer to have the day off. But I think that like the broader community would appreciate that we are observing the high holy days.
Thank you. Commissioner Goldman?
I did not realize that that was the first night of Hanukkah, so thank you for that. Hanukkah is not a major holiday, but I do light the candles, so now in light of that, I could make it if we have to, but it would be nice to not, to have that time.
Commissioner McCafferty?
I will be out on the 26th.
So do we have strong opinions, Commissioner Topson? You don't.
I'm not going anywhere. I'm here. So if there's a quorum, I'll be here. If there's not a quorum, I won't be here.
So we have 2 people who very likely will not be here on December 26th. Gets us to 5. We have several of us who have expressed an interest in not having a meeting that night. Do we have concerns with December 26th and running into any of the appeals going beyond what they're allowed to do if we push those to January?
I think that it will help having 3 appeals scheduled. So we are behind on most of the appeals that are scheduled right now on the 115-day timeline, so it won't necessarily assuage that concern or push us in that direction of being compliant with the 150-day timeline. But I do think it's reasonable, given the concerns that are stated, to look at a cancellation. And I think that certainly scheduling 3 appeals moving forward will help us catch up.
So I would like to suggest that this commission cancel the December 26th meeting, but not as part of the formal motion, that we just all understand that we're going to have a pretty heavy workload through November to January, February-ish. Do we catch up? If that seems amenable to folks.
Also, I won't be here on the 26th then. I'm not available.
You're not available on the 26th?
Or we are doing the 26th, or are we not?
No, I'm
Yeah, I'm not going to be here on the 26th. I'm unavailable on the 26th.
Okay. So that's 3 of us who won't be here. So I think it's probably with that we cancel the 26th.
And I'll definitely find something else to do on the 26th. So I'll
It's
plan
Boxing
something.
Day, right?
Boxing Day.
Yeah. Yeah. So. We use your mic.
Just questioning, so we're limited, right? We can't just cancel a meeting. We have to say we're not available, there's not going to be quorum, or there's not an agenda item? Is that correct?
On both of the other commissions I've served on, we adopt a calendar at some point in the year, in the months ahead, which is why I thought that might be a good practice here, because it will allow all of us to weigh in and just cancel meetings based on
If
an
it
actual
complies.
vote.
Yeah, if it
Or we-
complies with our bylaws, then I'm fine.
Do we have any concerns with the bylaws in canceling a meeting just because it's not a convenient day?
No,
Say it that way.
if we keep talking about it for 20 minutes, we will get to a point where you don't have a quorum. So I think that is what I am hearing.
Okay.
But no, not through the bylaws itself. There's not
Then I'm going to move that we adopt the commission meeting dates through 2025 as presented, except that we cancel December 26th.
Can I ask a question before we go and vote?
Of course.
Like, I know that we were talking about the workload being an issue. If we added compliance determination to, say, like the 14th or the 12th meetings, does that make sense, or is that a problem for some other reason to try and like keep the load balanced, seeing as we're apparently not meeting on the 26th?
Are you asking about like adding other dates to the calendar, additional dates?
No, I just mean moving
Another
the
appeal.
packets around to load balance against the missing of the 26th.
Yeah, as far as I'm aware, there's no upper limit on how many appeals we could schedule. Certainly, we'd want to consider the feasibility, you know, our ability to sort of be able to deliberate those well and thoroughly. But if that's a recommendation, the commission would be happy to receive it to add a fourth appeal, for example, to a certain night.
I could do that.
With respect, I would cap it at 3. I think even that's pushing it. And then I'd rather load 2025 with the 26 appeals as opposed to going for a 4th.
Chair, if I may, real quick.
Please.
So in terms of division of power, staff controls the calendar. We certainly take recommendations. But given, you know, just today we had 3 appeals come in, so it's a moving calendar. This is a soft calendar. So certainly I think we have talked in the past, and, you know, I won't speak for the manager here, but it shifts. So we hear that you guys kind of want to load up but not too much, and I think that's kind of the plan for the first few months. So we understand the desire to get things done, but not too much, and be here till midnight. So.
Well, not to beat a dead horse, if that phrase is appropriate, but or not, I don't know. But I will say that I trust staff to look at the appeals and recognize that some are a little bit meatier than others in the issues presented, and I trust staff to make those determinations based on how they're filling the calendar. And yeah, so that's my motion. I don't know if we need to formally adopt that. Since we're canceling a meeting, I think I'd feel more comfortable with that.
You can just do it by a voice vote.
I'll second the motion.
Okay, let's just, all in favor?
Aye.
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 All opposed? So the motion carries. Let's move on then to items from staff. Do we have anything additional?
Yes, there are a few announcements that I wanted to make. First, I wanted to extend a warm welcome and introduction to Brandy Thornton, who is sitting over here. This is her first week. She's just finished. She'll be stepping in as the new commission secretary, the principal commission secretary at least. As you know, Diane Garcia, who's here with us tonight, she joined us again, which is great. She was promoted to information coordinator, so she's helping out tonight, but you'll see a lot more of Brandy moving forward. Brandy worked before in the Department of Public Works in the engineering division. Prior to West Hollywood, she was working with the city of El Segundo, where she was the liaison to 6 commissions. So she has a lot of experience with commissions, and I'm sure that you all will enjoy working with her as much as we have so far this week. So welcome, Brandy.
Welcome.
My second announcement is related to the discussion surrounding a maximum temperature threshold for residential units. I just wanted all of the members of the community and the commissioners to be advised In January 2024, the Los Angeles County Board of Supervisors passed a motion directing the Department of Public Health to collaborate with other county departments to establish a safe maximum temperature threshold for residential units, to gather stakeholder input and prepare a draft ordinance. So we're in the stage of the gathering stakeholder input. There are two virtual events that are scheduled. One is for tenants, tenant organizations, and community-based groups. That will be on Thursday, November 7th, 2024, from 5:30 to 7 p.m. The Zoom link for that is on the website, on the landing page at weho.org/rent. There's also a second Zoom meeting for landlord organizations, building experts, and interested parties on Thursday, November 14th, 2024, from 10 a.m. to 11:30 a.m. And again, the Zoom link for both of these sessions will be available is currently available actually on the landing page of our website at weho.org/rent. Third, as the commissioners and any members of the public watching may recall, the city has recently adopted AB 1620 into the municipal code. The second reading and formal adoption was on October 7th, 2024. I wanted to advise that there are resources available now on our webpage. We have a template letter whereby tenants can submit the letter, fill out a little bit of information about their unit, and check the appropriate boxes, but submit that letter as a formal request for an accommodation under AB 1620. That is also on our landing page. Additionally, we have an informational handout for both landlords and tenants on the interactive process and reasonable accommodations generally. Those resources will also be available in Spanish and Russian, but they are currently on our main landing page of the website. Those are all the announcements for now. Thank you.
Thank you. Any questions for our staff? Commissioner Kerpes?
Can you just remind everyone at home what 1620 is and what the benefits of that?
Yes, absolutely. So AB 1620 allows cities to require that landlords engage in the reasonable accommodation process with tenants who are seeking a reasonable accommodation due to a disability that impacts their mobility if they don't have an accessible unit, and with certain other qualifications too, but that's sort of the gist of it.
Like, for an example, move from a second level story down to a
Exactly.
first, or exchange.
So if
unit
because
for-
of a disability related to mobility, they're not able to access their unit, they can request before the unit goes in the market to be moved to an accessible unit that's the same size or smaller under certain conditions. There are a few other conditions that must be met, but that's on the website. It's in the letter to all of the conditions that the tenant can check and say, I qualify for this, that reason. But yes.
Thank you. Any additional questions? Do we have any additional public comment?
No public comment.
Thank you. And then items from Commissioner, our last item.
I did want to ask, I'm sorry, the dates for the event. The LA County event?
Sorry, mic troubles. So for the tenants, tenant organizations, community-based groups, the date is Thursday, November 7th from 5:30 p.m. to 7 p.m. For landlord organizations, building experts, and interested parties, it's Thursday, November 14th from 10 a.m. to 11:30 a.m.
Great, thanks.
Any other additional items from commissioners? Commissioner Rory?
I would just say welcome, Brandy. I look forward to working with you. And nice to see you tonight, Diane. And thank you for Commissioner Council tonight. I appreciated your swift work on that resolution. And from the city manager's office, thank you for organizing our meetings. And my only comment is between now and our next meeting, we're going to have a big election. So everyone listening at home, please go out and vote. Especially for any California residents. There are ballot propositions regarding rent control and rent stabilized units, and we heard a little bit about that proposition at a previous meeting, so now's your opportunity to have your voice heard, and I would encourage everyone to do that, and in the meantime, have a good Halloween as well.
I echo everything the vice chair said. Welcome, thank you. And if anyone is watching this meeting this hour, my guess is that they're probably voting, but I would echo your sentiments that we encourage everyone to vote. And this meeting will now be adjourned to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on November 14th, 2024 in the West Hollywood Park Public Meeting Room, Council Chambers, where we are now. Have a good night.